Ron.
I'd like to welcome everyone to the Planning and Zoning meeting tonight, April the 3rd, 2014. And our first order of business will be our public hearings for this evening. And our first public hearing will be the amendment to section 405.050, definitions and interpretation. Mr. Hanford, if you want to come up.
Good evening, everyone.
Good evening.
First item we have is a proposed text amendment to section 405.050, definition and interpretation, ADM 67A. I'd like to ask that part of the public hearing record be the municipal code by reference, the public hearing notices, and my planning and zoning report. During the 3/6/14 Planning and Zoning Commission's meeting, discussion regarding the proposed text amendment request to Appendix A, ADM 67 was tabled, and the Planning and Zoning Commission requested revising the existing definition for a vacation or recreational vehicle in the municipal code.
Thank you. Anyone else here to speak on behalf or against this amendment tonight? Hearing none, we'll close that public hearing for this evening and open up our second public hearing, which was the extreme terror haunts. Mr. Hemp.
Once again, I'd like to ask that the municipal code by reference, my public hearing, my plan and zoning report, and the public hearing notices are made part of the public record. This is a site plan approval request for extreme terror haunts located at 1029 Armory Road. Property is zone C3 Highway Commercial. On February 26, 2014, a request was filed for site plan approval for a proposed seasonal haunted house. And per Appendix A, number 3, commercial use, A, entertainment event, major indoor entertainment facility. It is a permitted use within the C3 zoning district.
Thank you. Anyone else to speak on behalf of this tonight? State your name at the podium, sir.
Tony Gagliano with Thomas Realty Group. I'm here on behalf of both the landlords as well as the petitioner for the site. Just want to let you guys know, it's not a mom and pop type situation. This was a professionally type operation set up, purchased. It's a whole company that comes in, fire retardant equipment, everything to the top is lined. It's just not like a bunch of guys getting together and putting up some divider walls or anything like that. It's a full-blown 100% operation that was bought from another terror hunt in Florida, shipped up here. It would be constructed within the site, in conformance with the building codes. Now, I just got handed some stuff on some sprinkler systems so that we may be looking for a different building, but we'll go ahead and try to go through the process right now at this site, and if we have to come back to you guys with a different site, we may have to do that. But any questions regarding the operation?
If we do, we'll bring them up at the meeting.
Okay.
Anyone else to speak?
Mike Lumby, Warrenton Fire Protection District. I've got sections of the building code I'd like to give to you right now.
Thanks, Mike.
And we can go into more detail on this later. I just wanted to make sure that you all had this information. Not that it has any effect on the process that you're going through this evening. So.
Thank you, Mike.
You're welcome, sir.
Can I ask you a question?
Sure.
In reference to this, do you have any specific concerns with this particular use, or is this something that you would, the fire department would review anyway?
Yes, absolutely. We would need to review.
Can you step up to the podium so they can hear you? Thanks, sir.
Sorry. We would need to review the plans for the construction inside of the building, the alterations that will be done to the building. These are sections out of the building code, the 2009 edition of the building code, that govern special amusement buildings and what has to be done when you do that type of operation. Okay.
Thank you. Anyone else to speak on behalf of this tonight? Hearing none, we'll close our public hearings for this evening and open up our regular planning and zoning meeting. First order of business will be our minutes from the March 6, 2014 meeting.
I make a motion to approve the minutes for the March 6th meeting as presented.
Second.
Have a motion by Mr. Costello, second by Mrs. Scott, to approve the minutes as submitted. Any questions or comments? Roll call vote.
Mr. Costello?
Yes.
Mr. Deitch?
Yes.
Mr. Cullen?
Yes.
Mrs. Scott?
Yes.
Mr. Barton?
Yes.
Mr. Schoenfeld?
Yes.
Mr. Jurgesmeyer?
Yes.
Mr. Swab?
Yes.
Mr. Kohler? I'm sorry. And Mr. Dickey?
Yes.
Motion passes 9-0 with one absent. Next order of business will be the motocross practice session and safety training.
This is a special event permit application, SEP6, motocross practice session and safety training for April the 26th, 2014. On 3/19/14, Paul Owen B. Care of the Warren County Fair Board submitted a special event permit application, SEP number 6, for a motocross practice session and safety training event to be held at the Warren County Fairgrounds. City staff, including the zoning officer, building commissioner, public works director, and chief of police, have reviewed the application for special event permit number 6, and the proposed activities included in SEP 6 should not have any negative effects on the safety or general welfare of the public and our surrounding residential neighborhoods. And you have additional information in your packet regarding the track and the safety items they have in place.
And I'd like to point out that I do have a business relationship with the applicant, so I'm going to exit the dais until this agenda item is completed.
Thank you.
Do you know if this is a training for people who plan to participate in the motocross at the fair? Is that the idea? Oh,
I'm with the Warren County Fair.
Can you step? Thank you, sir. Yeah, we can ask you questions. Thank you.
I'm Lori Smith with the Warren County Fair Board.
Thank you. You want to ask you?
Yes, it is for the practicing for the event for the week of the fair. So for that motocross, but there are going to be no spectators at the event that we're wanting to have on April 26th. And I can have drinks or food, anything. It's just for practice.
And the facility will be set up the way it's set here for the, like it is at the fair type of things?
Yes.
And that's 9 in the morning, correct?
9 to 7. Yes.
Do you know the name of the group that was going to do the safety training?
I do
'Cause,
not
Paul
know
had
that.
mentioned you were bringing someone in to,
Yes,
for
we are.
training
They
the
were one of our
younger riders.
meetings, but I do not know the
he
name.
did not include the name. I
Yeah.
just didn't know if it'd be helpful.
I mean, I can get a hold of Paul. He's in Oklahoma right now, so I mean, I can get a hold of him if you'd like me to do that real quick and ask him what the name of the,
But it does say that the ambulance will be on standby that day and so forth.
That's what he's got in his application, yes, sir.
well, it looks to me like they've provided everything that we have asked for, and it's been reviewed by the city internally, and there are no issues. And we do have the detail that was a concern at the last meeting. So,
Well, this is a total different, if I understand what you're saying.
no, yeah, I
Right, with
understand
the-
it's a different thing, but we had
Concerns
concerns
with
about the
way
way
it's laid
things were
out.
set out, that we didn't have the detail that we needed,
Right.
and I think
This has covered that.
He's showing safety fence, he's showing hay bales and that to try to protect it. He's showing
Right.
specific parking areas.
Yes.
So
So, With that being said, I will make a motion to approve the, what is this, motocross special event permit as submitted.
And I will second that.
We have a motion to approve the motocross practice session and safety training as stated by Mrs. Scott, second by Mr. Deach. Any other questions or comments? Roll call vote?
Mr. Deach?
Yes.
Mr. Cullum?
Yes.
Mrs. Scott?
Yes.
Mr. Barton?
Yes.
Mr. Schoenfeld?
Yes.
Mr. Jurgesmeyer?
Yes.
Mr. Schwab?
Yes.
Mr. Dickey?
Yes.
Motion passes 8-0. Thank you. Next order of business will be the Fantasia Circus.
It's a special event permit application approval request, SCP number 7 for Fantasia Circus on 3/19/14. Paul Owen B. Carroll, Warren County Fair Board submitted a special event permit application, SCP number 7 for the Fantasia Circus to be held at the Warren County Fairgrounds on April 22nd, 2014. City staff has reviewed this application, and the proposed activities included in SCP number 7 should not have any negative effects on the safety and general welfare of the public and our surrounding residential neighborhoods. And if you want to give any detail, I believe it's a small animal show for the children.
No elephants running around the parking lot.
I don't think so, but if you want to give some detail, ma'am.
And once again, I'd like to state that I've got a business relationship with the applicant and will abstain.
My understanding per Paul is there's only going to be like 50 dogs doing like circus tricks on that day.
It says total attendance expected 50 people, is that right?
Yeah. Well, 50 people, and I'm assuming each one's going to have a dog.
So it's not something that is really going to have people coming in and watching? Is this?
To be honest, this is the first I've heard about this. So he called me, he was like, hey, somebody's got to get, he's in Oklahoma, he thought he'd be here, and he's not. So he told me to tell you guys that there would be 50 people and that it would be dogs doing like circus tricks and
50 people in the circus or 50 people attending to watch?
50 people attending.
Attending?
Yeah.
And it only runs for an hour and a half,
Yeah.
like
Yes.
6:30 to 8.
Yes.
What's,
Yeah, his description says an hour and a half small animal circus available to younger kids through the school. Circus is all small animals, dog tricks. All animals are small dogs. So, I don't know if he was just trying to generate something for the younger kids in school.
Yes.
But he didn't really think he was going to have a giant crowd out there for it. I think it was just something to try to help put something on for the younger people in town.
so this is pretty much restricted to school?
Well, I think it's open to anybody, but I think that's where it's my understanding that's where he's trying to promote it.
Okay, so it's not a special activity geared strictly for a group of children from the school?
No.
I don't believe so,
No.
no. It's not stated in his application, but I think that's where he thinks his draw will be.
I don't have any concerns about it. I just hope his turnout's better than he's anticipating.
So am I.
There's your sirens. There's your sirens. There's tornado on the ground north of Washington with an east.
So do we have to be going?
Yeah, a little bit.
I'm going.
All right, we'll postpone.
You're going? Say, can we just finish meeting downstairs? Can we meet in the mall?
Run.
We're back to meeting. And we were in the middle of the Fantasia Circus, getting ready to discuss whether or not we had a motion or not.
Hearing no concerns from the board or from the people at the city that reviewed it, I would make a motion to approve the Fantasia Circus plan as presented.
Second.
We have a motion by Mrs. Scott, second by Mr. Deach to approve the Fantasia Circus event as submitted. Any other questions or comments? Roll call vote.
Mr. Colon?
Yes.
Mrs. Scott?
Yes.
Mr. Barton?
Yes.
You doing the next
Mr.
one?
Schoenfeld?
Yes.
Mr. Jurgesmeyer?
Yes.
Mr. Schwab?
Yes.
Mr. Dickey?
Yes.
And Mr. Deach?
Yes.
Motion passes 8-0 with one absent and one abstention. Thank you.
Thank you.
Next order of business will be our amendment to section 405.050, definitions and interpretation. Mr. Graville, you have the floor.
Thank you.
Thank you for being here.
Jack sent some stuff for me to review, and as we kind of got into the discussion about it, we kind of decided that maybe it would be better if I was here to answer questions, maybe do a little brainstorming with you guys. So I took some of the information with the revised definition that Jack gave. Well, first off, Jack gave me the revised definition, and my concern with the definition as it was written was a couple of things. Number one, when we broke the language down, we thought that it created an exception that would allow basically someone to live in their motorhome in a residential property at all times, and I don't think that's what the intent was when we really broke down the language. Number two, our concern was in the commercial district allowing up to 4 on a lot. Remember, there's no lot size minimum in the commercial district, which would create a situation where you could take an acre lot and subdivide it into a bunch of little lots and have up to 4 recreational vehicles on it, and really kind of get around the recreational vehicle park exception. And then, so basically when I talked to Jack, I said, you know, this is a definition here. We had a little bit of zoning regulation in the definition before, which was probably okay, but it really was not a definition anymore. It really was a regulation, and our thought process was, let's break this out into a new section in code and really break it out into 2 separate concepts. Number one is recreational vehicles in a residential setting and recreational vehicles in a commercial setting. And I think that's probably a better way to approach it as we kind of try to hammer out the recreational vehicle issue. And then I also want to get to the request of the Elks Lodge, which is a text amendment, and kind of talk about that as well. First off, and I don't know where you guys want to start or what you guys want to talk about, but I just took our definition, I took all the zoning regulations out of it. And I don't know if you guys have that in front of you, but I took just all the zoning regulations, even the ones that we originally had in it. And then I took some of the concepts and I busted out my notes, and I had a conversation with Teresa about this as well, as what our original intent was when we did this and what ended up being what was written. You know, you look back at it after a couple of years and you're like, was that really what we thought and really what we kind of did? And so I kind of created this new section that's parking of recreational vehicles in residential areas. Recreational vehicles shall not be parked outside of a fully enclosed building or structure. And then the exceptions with regards to the kind of get home from vacation, get it cleaned up or get it packed up, get it charged up, how many times, 2 occurrences a month, saying, you know, you can kind of go back and forth 2 times a month. And then the 48-hour occurrence and how we could kind of govern that 48-hour occurrence. Now, one of the things we talked about when we discussed this as staff, is there really an issue unless it's in a city right-of-way with a recreational vehicle parked in a residential area? You know, a recreational vehicle being parked in a neighborhood. And that was one of the concepts we wanted to pose to you guys, to say, is this something that's an issue that you guys even want to regulate and say, well, you can park it as long as it's licensed and it's, you know, can move. You know, it's not flat tires and it's not derelict. You know, and it's behind, you know, the property line. It's not a viewing distance, not a sight distance issue, such as on a busy street where it blocks, it's too tall where it may block a turn or something like that. So these are kind of the suggestions we have on the residential side, and kind of one of the things we wanted to talk about. Now on the commercial side, it becomes a bigger issue because the way we have it set up now is that we have recreational vehicles with this proposed in the residential district, and then the commercial, we really have, you know, the park, where we get into the park, we define the park. And the thing I wanted to say on behalf of, you know, the applicant is they have applied for a text amendment to make it conditional use. They've requested that change, And, I don't want to speak on behalf of the Elks, but I think one of the things we have to consider is if we're going to go back and we're kind of revise these commercial regulations and what happens in the RV, do we vote on their conditional use or their text amendment and take that up before we really get into the meat and potatoes of revising it, if that makes sense. So, the concept being, I think we probably need to think about revising the whole recreational vehicles in the commercial district with some of the ideas that have come up. I'm worried about what we did in the definition because I think it creates an ability for anybody to build a recreational park and to get around it because we don't have lot size minimums in commercial districts. So the idea being maybe it's better to vote on their proposed text amendment so they can move forward and then we can kind of come back, talk about some ideas for recreational vehicles in commercial districts and come back, with you guys with some proposed suggestions. So that's kind of why I'm here and, kind of here to brainstorm that idea.
Okay, and we have a business relationship with the Elks, so if we're voting on the text amendment, I'm going to abstain.
Right.
However, if we're talking about changing the ordinance that affects the whole city, I'm going to participate in that discussion.
And I think that's
as long
absolutely
as you don't
appropriate.
think that's okay.
And I think one of the things we got to figure out is, I don't know that the definition works, and I think you guys can kind of get conceptually why, and that's why I wanted to be here, was the problem is that it just, we probably shouldn't have put that much zoning regulation in the first place. We kind of tacked it on because we were just talking about residential. Now, it kind of overloads it, and it's in a definition section, so the concept being, let's create a recreational vehicle section where it's very clear it's black and white. So I think talking about it citywide, I think you guys have to give us kind of an idea of what direction you want to go in residentially, what direction you want to go in commercially, so we can bring some proposals back and then see if they want to wait for some changes or if they want to vote on it so they can try to move forward.
Well, I don't know where exactly you're saying we need to start, but I have some huge concerns with the, the parking of the recreational vehicles in residential areas, R1, R2, R3. Right now it's restricted to back or side yard by what's in the definition. This would basically mean no one could park a camper on the majority of lots in the city unless they were in an enclosed structure. If it has to be 500 feet from a structure, most lots are, the standard size lot's 70 by 120. And there's a lot of them that are
Well, and like I
there.
said, Teresa, this is just something that there was, looking back on the history of it, so, it's very simple to say, if we're going to get back to, if you guys want to do the side or, backyard, that's very easy to put back in. It was trying to get a starting point to say, let's create a regulation, because the definition it's not very clear or very well defined. So, was to try to put something more detailed together, and really my focus in putting the definition together was on the concept of not allowing it to be parked, because that was a theme, was not allowing it to necessarily be parked there permanently, maybe outside of the side and the front, but allowing it to be there to kind of clean up and whatnot, that window, kind of concept. So it's very easy if you guys want me to add that language back, put it in here about the side and the back, like behind the side and the back, no matter what.
Which is consistent with utility trailers, I guess trailers with boats and that kind
Sure.
of thing. It specifically says that they can be parked on the side and the back. The ordinance on the trailer said they can be parked not in the front yard, but other places than that. I just think if we go with this 500-foot thing that we're really,
And that's fine, it was
Limiting.
a shot out there to come, kind of put something out there, looking at a couple of different cities and looking kind of historically based on my notes and what we had talked about previously. Because we had talked about what were we trying to do when originally this was written. And it's not very clear in the definition, the way it was written. But if you guys are kind of good with that, I can take that back and put that side back explicitly in there so there's just no question and get rid of this 500 feet thing.
I thought the kind of general gist of the conversation, at that point I wasn't participating in it, but I thought the gist was to basically not change that portion of the side and backyard, but simply to make it where someone could actually access their trailer when they needed to load or unload. And I'm not sure if saying you can do it 2 times a month is enough either, because in the winter, they're probably never going to pull it in there. But they might have 2 weekends in a row, and if you have 2 weekends in a row, that's 4 times, because you got to load it, you got to unload it, you got to load it, you got to unload it. So,
Well,
I just don't know that it does exactly what we
The problem with the language that
wanted.
was submitted, that was revised when we looked at it, it created a situation where the way that, when we broke the language down, where you could plug it into electric, live in it, plug into electric and live in it, and really be there all the time. The language that was suggested that Jack asked me to review. So that's why we tried to, so we could make it 4 times, and really, you think about enforcement of this, it would be a complaint-driven thing. It would be something where, we wouldn't have an officer sitting out there being like, the trailer moved, I mean, that just would be something where it would become a nuisance, then we'd make observations on it, because, and that's also, we talked about conceptually the concept of just saying, do we create in a residential area where you just say, as long as it's not parked in the city right away, where it's not parked where, and right away being also where it could block a sidewalk, or something like that, where it could block you don't want it parked where it blocks, a travel path, or it blocks sight lines or whatnot, with a kid riding their bike going around it or something like that. If we just said, if it's not parked in the city right away and it's operable and licensed, can it be parked there at all times? And just really make it at that in a residential area.
So you're
Because
talking
it did modify the residential area when it talked about the utilities and what it did. And that's why we brought that in there, is that I know you're saying that you weren't part of that discussion, but the way the language read, it totally changed that concept of it. So that's why we're trying to understand and break it down. You know what I'm saying? Because the way the language was written, and that's why we're like, okay, well, let's just create a section and try to get an idea of what you guys want, bring it back to you, get feedback, and then bring it back to you again.
I think a large part of the discussion, it evolved out of the question on the commercial use that was requested, but I think a lot of the discussion really centered around the fact that right now, anyone that owns an RV or a camper or something of that nature, if they're preparing for a trip, they want to go on vacation, whatever, they essentially have to break the ordinance to bring it home and load it up. And I feel like that's probably overly burdensome. I'm not aware that the city necessarily goes out and writes wholesale tickets all over town when people get prepared to go on vacation or return from vacation, but I think our ordinance ought to conform to realistic and reasonable use of those types of things. And I think we need to balance the interests of residents that have those with the interests of neighbors that may not want to have a 32-foot RV in the driveway of the house next door 365 days a year. I can understand where that's not ideal if you're the next door neighbor. So I guess the art is in how to craft something that allows people that enjoy camping and those types of recreational activities to have some reasonable ability to use the campers and prepare them at their residence where they've got the tools and their belongings and things that they need, and then yet protect the individuals who don't want to have the afternoon sun blocked from their yard every day of the year.
Block out the sun campers.
Yeah.
They're out there.
Well, I gotta be honest, I've only been on an RV to go to a Mizzou football game, so I really don't know what it takes to.
Well, somebody had to keep that RV somewhere for you.
To prep it to get on and prep it to go home. So I looked at other cities and cities that regulated. Some cities, you can't put it in residential property at all for any period of time, and it has to be off-site storage. Some cities have no regulations on it. This was kind of in between, and it was a shot in the dark about a time period to, really spur discussion to say, well, how long does it take to prep it? And, do we just say, for example, do we eliminate no more than 2 occurrences per month and just say no more than 72 hours per occurrence? But then the problem becomes, what is per occurrence, Do we let them park, the issues I see, do we let them park it in public streets for a period of time, public right-of-ways, which then block a sidewalk or something where we would get a complaint? Or a narrower street would be an issue. if you let them on the, park it on their property to load it up and leave, how many, do you make it 4 times? I mean, it's arbitrary, because, you're trying to guess. And like I said, I've never taken an RV trip except to go to football games, so I really have no idea what it takes to set it up. So that was kind of where we got that information from. So I'm looking for feedback from you guys, so I can put something together that, really, it takes that balance, as you said, Scott, into account.
And you want to, currently they allow them to be parked in the backyard or the side yard?
Yeah.
Side yard of the house?
Yes, yeah.
And if they didn't currently allow that, I probably wouldn't be saying we need to allow that. But it is currently allowed, and,
And all types of, there's no regulations on what
Well, if
type
it was,
of...
it would fall under a derelict or vehicle if it was unlicensed, or like how big. No, we don't. There's some cities have regulations with, you can only have this size behind your property line, or this size. But I think the idea being, if it's in your side yard and your backyard, but it has to be behind your property line, it's not going to be as visually.
Yeah, I mean, I have a neighbor that parks a motorhome in their backyard, and we don't have big yards in my neighborhood, and I gotta say, I'm not terribly crazy about that. I mean, it's a motorized 4-wheel driving 1972. It's licensed, but it's in their backyard, and it's ugly. And I know that doesn't fit every situation, but that is a concern of mine. Being parked there all year long and in the middle of somebody's backyard.
Is it on the grass?
Yes.
And that's maybe something else we can look at is
I was going to say, there may be something else in the ordinance somewhere that might address
require
that.
it to be parked on paved surface, but they may just gravel it then.
There's nothing that requires
Nothing,
paved or
gravel,
gravel surface.
pervious surface. So then that's another issue, it's just, honestly, it's, this was a big discussion when we did it before, and this is the discussion, is just trying to get some feedback from you guys to say, once again, it's coming up, and maybe that's because it's vacation season, or it was spurned by the commercial talk, but I agree that it makes sense, but how do you regulate it? If you say, the thing that I get concerned about, it's an arbitrary number when you say 2 occurrences per month. I know that's completely arbitrary. But there's some regulations because, you can say, okay, what are 2 occurrences? And you can kind of look at it. And if there's someone who complains, you can kind of document it and whatnot. It becomes difficult to say no occurrences, or if you say 4 occurrences, then what are, it would be more difficult to kind of regulate. So I don't know that there's definitely not a magic ordinance out there. I don't know that there's a magic definition that'll fit them all. I think our definition is really good, and I want to leave the definition alone. I just think we need to kind of extract the zoning regulations for the residential districts and just really try to figure out these are the things we want to do and how we want to do it.
Could we just ban people from residing in it, or sleeping in it overnight, or living in it while it's parked in the driveway or in the yard?
We can. I think there's a couple issues that come up, with regards to the utility aspect of it is hooking it up, and I guess primarily electric, because I don't know that you could really hook your sewer up in any way, shape, or form. Or, one of the concerns we've had from Public Works before is the hose is not having a, what do you call that?
Backflow.
Backflow preventer hooked up to it is one of the concerns that they've always had, especially in a large group, is the backflow preventer, creating an issue with city water. One of our former Public Works directors had a real issue with it. I don't know that we've really talked to Guy that much about it currently. Is it, how do you regulate that? How do you say you can't live in there? Well, I'm not living in there, I'm just going in there, or I fell asleep, I'm taking a nap in there or something. What is residing in there, what's being in there? And that really becomes the issue, is trying to put something realistically in place that is enforceable, and it's not the people that are willing to follow the rules or just don't know the rules and we have to tell them what the rules. It's, the people trying to get around the rules that, really probably become the nuisance neighbor or the problem. It's probably easier to just regulate its location on the property than living in it or utilities hooked up to it or whatnot, because, I don't know, do you just hook a garden hose up to them, Teresa? Is that what you do? You know, because they're going to probably be able to do that anyway, and you can hook a garden hose up to a lot of things, you know.
Or you can just fill it with water and then you don't need the hose.
And then you don't need the hose. So, you know, what is the easiest way enforcement-wise to regulate it? I think location on the property or being on the property for a period of time. Beyond that, it does become kind of arbitrary. And if it's in the backyard, for example, what is our city crew going to have access to go make observations or investigate? They're going to be going to the neighbors and saying, can I look out of your backyard to see what they're doing out there? Because they may not have access back there to look at it, or to go in there and really see living conditions or whatnot. So, I mean, I know it's just RVs, but you know, this was a big discussion before, and it's kind of an enigma in figuring out how to regulate it.
And if you set a specific time period, say 72 hours, then even if they're staying in there, they may be staying in there and they're living in it for 3 days, but they are not living in it full time. So, and that may be, I mean, the set time may help to alleviate some of those issues. Still, if somebody came in and they were staying for the weekend, they could stay in it. But, and if that's an issue, then we would have to write it differently, but.
I see a real problem enforcing this. I mean, how are you going to enforce this?
The way this is written?
Yeah.
I agree with you, but it's probably the one that is more enforceable than the other ones. One of the issues was, in the definition that was drafted, was the utility, it had utilities for 48 hours, or the gas generator or whatnot. Is enforcement of that is, you have this continuous period, how do you do that? This is a little bit easier to enforce because you're talking about a large vehicle being on a piece of property where it can be observed, and we put in this provision that I like that talked about, you know, the duration of permitted temporary parking shall run continuously from the initial time of the parking occurrence, even though it may be parked at various points during that period. It's going to be complaint driven. It's going to be the neighbor.
That's how it's going to happen.
It's going to be Scott coming in and saying, you know, my neighbor's parked this vehicle here for this amount of time. But that's really probably where the complaints are going to be generated from anyway. Sure. You know, it's going to be them as a witness and say, this is what it is. An officer going out and saying, or a code official going out and saying, I documented this parked here at this time. You know, I came back at this time, and, you know, I came back and I documented it here at this time. You know, that's how we would do it. I mean, it's how we'd have to do it in a situation like this. But utilities or living in it becomes very difficult, because defining that and knowing what they're actually doing, it's like, well, that extension cord's running from my RV, but it's just laying on the garage floor. It's not plugged in, and the garage door is closed. Well, how do we know that it's, you know?
Exactly.
I don't think any of the judges in Warren County are going to give us a search warrant to go look in the garage, you know, to take a look at it.
And to be quite honest, if you've ever heard a generator running, you'd rather have it plugged in if you're the neighbor.
Oh, yeah, I've heard that. I may not have been on an RV, but I've heard a generator running, so yes. And that was the kind of the thing, is the gas generator is, it's trying to come up with something, guys, this is just kind of something to put out there and say, well, let's come up with regulations within residential and just try to hammer it out and see if we can do it. I think it can be enforced. Are there issues with enforcement? There's always going to be an issue with enforcement when we can't have somebody there 72 hours straight observing it and making notes and, you know, taking pictures of it.
First of all, you got to know when they parked it.
You do have to know when.
Nobody's running around writing that down either.
Well, but it would be a neighbor saying, I saw him park it at this time. City official going out and checking it, and it would be, you know, he goes out, checks it, and documents it, and then comes out and checks after 72 hours later, it's still there, and, you know, that would be.
That sounds good for one. You got 100 of them all around town here, probably.
I know, but we have building code issues that. There's issues that happen all the time, and really it's mainly complaint driven too, so.
And it'll have to be complaint driven, I think.
Well, you just hope that most people would do to the best of their intent, follow the law. And a lot of times it is ignorance, but at the same time, I think you're saying location and time driven would kind of help us.
rather than try and enforce it after the fact, to me, I think it's reasonable if the ordinance were written to put a burden on the RV owner to notify the city that they are going to have it on the residence premises.
Well, we talked about that. We talked about doing like a no-cost permit to do something like that, and then, and the idea being, one of the things we were worried about was, are people going to say, well, here's the city making me get another permit, kind of concept, which, we do hear quite a bit is, that was...
If you're an RV owner today and you can't do it at all, I would think the opportunity to get a permit to be able to have it there as you prepare to leave town is actually an improvement of the existing situation.
Well, actually, the existing situation, and when this discussion was had initially, basically they said, we're going to put it that you can't have it there, but the enforcement is going to be, if they see it there, they're going to come and give you a pink slip and you have 10 days to move it. So you move it into, and that was the enforcement. That's just how it works. So you park it there, and if they happen to see it, then you get a pink slip, and in 10 days you have to move it.
So you get 9 days free.
So you
And then you move it for a day and bring it back and you get another 10 days.
Well, you
Right.
could,
I mean,
but
technically-
normally I've gotten a pink slip, I'll tell you. I've gotten a pink slip because I knew that was how it was designed to work, because I sat up here when that was discussed. So, no, you don't, we don't park our RV at our house unless we're loading or unloading. It's not in the side yard, it's not in the backyard. And, so, like I said, I don't have a problem with the 500 feet thing, but I just think there's a lot of people in the city other than me that would affect, and it's not all about me, I just happen to have an RV. So, but you get that pink slip, and then you move the RV. But we would have moved the RV anyway.
Right.
So, and it seems like a cumbersome way to do business for the city to have to leave a pink slip, and so.
Yeah, I will tell you, city staff is okay if you guys want to say it's okay to park it there. Because it's not, it's a situation where, it's very black and white. It's hard, very difficult to come up with something very black and white that kind of fits these exceptions in here for what wants to be, what, people want to be able to do and recognize those and come up with those. And, that you're right, it was like a system that was basically set up that was like, well, we're going to give you a warning, we're going to give you time to move. And, as things change, as, enforcement changes, then I think that's really where some of those discussions came out of, I'm getting a ticket now, I'm not getting a pink slip or whatnot. But it's just trying to come up with something in between or something in the middle. Like I said, there is no magic ordinance in this situation, none that I can find or come up with or think of, because it's difficult to know, to really say when is a vehicle parked there permanently or for an entire period of time. So you come up with this kind of language that it's continuous, the clock's meter's continuously running. It's difficult to say how many times, a month you should be allowed to unload and load your trailer, where you should be able to park it on your property, how long it takes most people to load and unload, although it seems like the 72 hours is probably a pretty good estimate. It's just hard to come up with something that really works. And like I said, and I've said this to you guys before, it's got to be an organic code. So if we come up with something that doesn't work, let's try to come up with something maybe new that may work,
I think these type of ordinances are more designed to protect the neighbors and the neighborhood from the problem person than to be proactively enforced and have somebody going around with a time clock, clocking RVs and how long like you said, complaint driven.
Absolutely.
And if it's not a problem, then it's not a problem, even if it's there 73 hours, if no one calls, then.
But I kind of like what Scott was saying though about, when you have the construction, they give you a permit and it's got a date on it. You get a new car, you get 30 days to license, there's a date on it, stick it in your window. How many times does a camper, are you talking 10 times, 12 times a year? You come down and get a permit that says 3 days, or, if we're allowing 72 hours, they get a permit that says a date on it, you stick it in the front window, and your neighbors know that they have until that day to get it moved.
What do you guys think about the permit concept?
I am absolutely completely against it. And I'll tell you why. Number one, it's going to eat up city staff time. And number two, the city is only open from 8 to 5, and that does not fit in everybody's, doesn't fit in everybody's time schedule.
Well, I agree, because it's kind of like, they don't issue me a key to the dumps out there either, because, just because I work for the city, they won't give me a key, but I still have to check it out between 8 and 5, and that's a nuisance for me too, because I don't have that time, you know. So, I mean, I agree with her, I understand that, but we gotta come up with something.
If it's complaint driven, and we don't have, I mean, I don't know that, do we have a lot of abuse of this? Is it I mean, really, the only reason we're talking about it is because it came up with the Elks issue. So, is it a problem in the city?
I think most of the time that I'm aware of, it's what you described, Teresa. They would get a notice, they've got 10 days to resolve it, and by the 10th day, they're either on vacation or it's moved.
Right, because they were either loading it or unloading it.
I could see though how if we let them hook it up to power and utilities, that it could become more of a problem.
Well, really, why we extracted it from it was the hooking up to power and utilities. And the way the language was written, it was like, okay, we really have to define this further if we're going to let. And so what we tried to do was take the utility concept out of here, which is difficult to regulate, and really just try to take the concept of someone plugging it in, getting it ready to go for a trip, and really just try to put the regulations in that we thought we could recognize and regulate, if that makes sense, Scott. So, I mean, we can kind of go back to the way it was before, and just not create a separate for recreation. I don't know, you guys tell me, or you guys give me some suggestions if you want us to put some suggested permit process together for you guys to consider, or you want to put, I don't know.
So would this be, the changes that are here now, so like Scott was saying, that somebody, because it's in their backyard, but it's been sitting there all winter long, would this give more power to the people to be able to call to make a complaint?
Yes, absolutely. I mean, the way this is written, as Teresa pointed out, it doesn't allow side and backyard parking anymore, which was just, honestly, it was an oversight, omission, that I just was more focused on the people going to the property. But yeah, this would, the way it's written, would give more power to the neighbor to say, Scott could call and say, you know, it was parked there. I mean, they would probably have some legal non-conforming until they moved it out for a trip. And, you know, then they wouldn't be able to bring it back there and park.
But that would be complaint driven, and it also wouldn't hinder if it's my neighbor who tells me, you know, I'm going to have it in the backyard for a week, but I'm under that understanding, and that's fine. They wouldn't be hindered by that, and it would be something in agreement. So being complaint driven, I think, would be better. I like the idea of having the 3 days in the window, but at the same time, like you said, it's banker hours for the city, and a lot of times they might be doing something on the weekend, so I don't know about that, if that would be a good option.
Well, I think we have 1 day a week, is that right, Mayor, that we have extended hours? Is that what it is, Brandy? 1 day a week?
For bill paying.
Yeah.
And it might be something we could set up on the city website.
Yeah.
If there's no fees involved, more just the information and the location, they might be able to apply in advance.
Like an email permit or something.
And then we could send it out to them, or they might be able to download it themselves and put it in their window, and we would be able to document it. You know, that they received it off the website.
I was suggesting more of a notification. I mean, the permit thing has some value in that if someone, an enforcement officer or whatever, was driving by and saw that it was posted on the windshield,
just keep on
they don't even
driving.
have to, they could just keep on rolling. But, you know, my thought really centered around just notify the city, look, we're leaving on the 12th, so for the 9th, 10th, and 11th, I'll have this there. And that we have some system, like Mr. Hampton said, it could be an online registration, but we have, if we had just some simple system of noting that this particular address notified the city that the RV would be here for those days. I certainly don't want it to be an obstacle like Teresa indicated where, for somebody that works and is out of town during business hours, that they couldn't take advantage of the freedom.
Well, that type of system, if we could do something like that, enforcement would be, I think, fairly easy because it would be fail to notify the city of, an RV parking. And it would be very easy to track it and very easy to say, you get this many times a month, this amount of time, and, we could put provisions in there, Teresa, that would say, warning, enforcement, blah, blah, blah. I understand this has become over-regulation, it's just,
That's kind of where I'm at.
yeah.
Yeah, I
I
agree.
think we're just kind of getting,
Maybe we're trying to put a regulation in that we really don't need. Why don't we leave it like it is, let it be complaint-driven, and see if we really got a problem here? We don't know whether we got a big problem or not.
That would be, and that's fine. I think what we've had has worked for a little while, but like I said, the concern was the utility concept, bringing that, or the hooked up to utilities, bringing that into the definition, and the way it was kind of worded was, okay, now that we have this, let's kind of take this out, and, so we could leave it the way it is for residential right now, if you guys want to just maybe see how the summer goes and see if it's still an issue.
Yeah, I don't think we know there's a
Permits.
real issue yet.
Yeah, you're not going to you'll have half the owners of RVs who just will ignore it. And so then, are you going to have someone driving around looking to see what's in the windshield?
Well, yeah, and I want to say this, there are enough complaints about properties in the city that our two code of compliance guys are busy handling that they don't drive around and look for issues.
Just seems to me that we're creating maybe a problem where we don't need to have one.
So maybe throw this issue, table this for now, and then kind of leave the definition alone. Then maybe we can talk about the commercial aspect of it a little bit, if that's okay with you guys.
Let's find out if we got an issue before we try to solve it.
Okay. Are you good with that, Teresa? Okay.
So do we need a motion to table it?
Well, I don't know that, is it on the agenda, the specific amendment, or?
The definitions and interpretations, yeah.
Okay, so yeah, if we could have a motion to table it, then,
but if you're going to talk about the commercial, is that not under the same agenda item?
No, it's not.
No, it's on the
Okay.
original one. And
All right.
can I have one question before we
Yes.
table it? On the definition, it talks about are parked in any required front yard, and would the front yard area include the driveway? Because I think that was sort of some concerns that Teresa had. She had a licensed camper parked on a concrete driveway and got rode up.
But by definition, that is the front yard, because the
Yes.
front yard is, and like I said, I don't have a problem with it as long as they give me the little pink thing and I have 10 days to move it. I'm okay with that.
Okay.
do you save?
I'd like to know who's complaining, but
Do you
okay.
save the pink slips?
No, but he sent them to me the other day when I asked.
She had me send her new copies.
But no, I just think the way it is
It's okay.
it's okay.
Okay.
Because it allows you to do what you need to do.
Well, I'm all about not changing something if it works.
But I
because-
hate that somebody has to take the time to put a pink thing there, but,
You lawbreaker.
yeah.
Laissez-faire.
Okay, so yeah, if we could do a motion to table it, then we can kind of
Okay.
talk about the commercial.
Entertain a motion
aspect.
to table amendment to section 405.050 definitions and interpretations.
So moved.
Second.
Mr. Deitch, second by Mr. Dickey. Any questions? Roll call vote.
Mrs. Scott?
ADM
Yes.
67.
Mr. Barton?
Yes.
This one here,
Mr. Schoenfeld?
not the appendix.
Yes.
Mr. Jurgenmeier?
Yes.
Mr. Schwab?
Yes.
Mr. Dickey?
Yes.
Mr. Costello?
Yes.
Mr. Deitch?
Yes.
Mr. Collins?
Yes.
Motion passes 9-0.
Okay.
It'll be a conditional.
Next order of business.
Well, and I think then that brings up the next order, the next thing is, okay, so the concern about the commercial aspect of it, and I don't want to speak for you, Mr. Horner, so jump up at any point if I don't correctly represent it. But I think, once again, it gets back to our concern in the change in the definition in the commercial district. When we looked at it, we said, okay, there's no lot minimums in commercial. So it would be easy to create a RV park in the commercial. And I know part of the intention is to allow them to do what they want to do without creating a precedent or creating the issue in that, is it C3, Jack?
Yes.
In the C3 district citywide. So to kind of bring that back to you guys and say, okay, do we want to kind of come up with some alternatives, or do you want to come up with some different commercial regulations? I mean, right now, it's pretty black and white, where it's like, a park is this would qualify as a park, even though they're not trying to run a 50 RV park. Or do we just take it, make it conditional, or give them the opportunity to present a conditional use permit and a site plan on it so they can move forward on it? So that's kind of my thought on it is I don't know that the intended, that there's some unintended consequences by doing the up to 4 on any lot in a commercial district, because you could basically create an RV park with no regulations in that situation.
Okay, and since we're back to specifically on this topic, I'm
Gotcha.
going to abstain.
Can this be made conditional for, say, a year, and every year you gotta come back and renew it?
It has not been the practice in the city to put a limitation on a conditional use permit, but absolutely Missouri law allows you to make a conditional use permit for a limited period of time. In fact, Warren County, it's their practice to make it a year and then review it for longer periods of time after the first year.
That would make sense.
Yeah.
Well, this would keep somebody else from wanting to create a park, possibly.
Well, I think, well, can you deny a conditional use permit? You can deny it if it's reasonable and it's not arbitrary in your denial of a conditional use permit if somebody wanted to create a park. But I think more generally, the concept is every piece of property is unique, every application for conditional permit is unique. So, I don't know that somebody else coming and doing what the Elks want to do is going to be the same or different or whatnot. And is going to have the same requirements, the same conditions or less conditions. But you could give them a conditional use permit that ran with the land for as long as they wanted to do it. Or you could, and somebody new coming in, you could make it for a year. One of the things you may want to consider doing with regards to what the Elks want to do, if you do agree to give them the text amendment, and then in the future, you give them a conditional use, you may want to tie that conditional use specifically to the applicant and the owners of the land, so they cannot lease it or sell it as an RV park to some other entity later on and say, hey, we got it, now we're going to sell it to you. Because we typically run it with the land where it's kind of owned by the land and not by the person that applies, which is kind of another idea, with regards to that particular property. Not that I think they have any intention to do that, but, to alleviate some of those bigger concerns with making it conditional in C3 and not wanting to allow C3 RV parks.
My concern is less about the specific use at that specific location. I think I've been on planning and zoning for 12 years, something like that. I always look at things as what is the worst that can happen if we allow this. If we make our C3 zone a conditional use for RVs, we and the Board of Aldermen that are in place today might have a very clear idea of what is conditionally acceptable and what isn't conditionally acceptable. But 5 years from now or 10 years from now, someone may come forward that wants to put an RV facility in. And it might not be desirable. It may be that the Planning and Zoning and the Board of Aldermen all agree, and we have a new city attorney by then and whatever else, all agree that it's not something that's beneficial to the city, and it's something that they don't understand how they can say no, because it's conditional. I always feel when we consider conditional uses on any piece of property that we're very limited in our ability to deny something, even if we feel like it's not a good fit, because it is conditionally allowed. So our code says specifically we're willing to consider allowing this in this zone because of its conditional use status. So my concern is that in solving this problem by granting conditional use, we really potentially open a Pandora's box that we may not ever see an issue on, or it may be 7, 8 years down the road. But at some point in time, we could end up through the conditional status of having a very unintended consequence.
What about the concept, kind of, like I said, thinking about a brainstorming, kind of doing, Scott, what we've done with the kennels. Over 3 is a kennel. The idea of either coming up with a mid definition that could be conditional and have a minimum lot size. Like how big is the lot that you guys have behind the Elks?
The additional lot that we have there, which we just bought a couple years ago, is, I believe it's a little over 1.5 acres.
Okay, but is it going to be all dedicated towards this?
No.
Okay.
And if I may, I can reiterate.
Sure, like I said, you got to stop me from talking because I'll keep going.
Just to reaffirm, I'm Don Horner, I'm representing the Elks Lodge. What our intent is, we have visiting Elks members from throughout the United States coming through this area, and most lodges have a place where they can park their RVs, normally for 1 or 2 nights. In the 15 years we've been up where we're at now on Veterans Memorial Parkway, I can remember only 2 times when we had over 2 campers sitting there. Now, I will plead guilty to ignorance of the ordinances. We didn't know it was against the rules, but as far as the utilities, we have no intention of making at an RV park. We're figuring if we get at the most 4 units on that place at a time, that would be the absolute most. And then you have to be an Elk member or their guest to park there. And we have absolutely no intentions of running water and sewer to it. It's just strictly a plug-in so they can run their air conditioning during the summer, or, heater or whatever, and not have to burn a lot of propane, to be honest about it, to do it. So, that's our full intention, is that additional lot that we have there that we just bought a few years ago. You go about 50 or 60 feet off of our concrete surface, there's electrical outlet right there that, my understanding, years before I moved here, which had been 36 years ago, is there used to be a car lot there. So there's electrical to a pole out in the quasi-middle of that property that's still available. And so we just wanted to put a couple stanchions there where it's on an RV could pull in and plug in and not have to park up alongside our building and run their television and air conditioner in the evening. And like I say, the only time I remember in my 30 years of being a member and the 15 that we've been up there, anybody staying 2 days, there's been a couple came out here and they parked there, and they had a motorhome, and they pulled a vehicle behind it, and they were doing activities, and I think one of them was the Renaissance Fair in Winsville, and then they went on into St. Louis. So they were here 2 days. So, but no, it's cost prohibitive to us to even think about putting water and sewer in there, because, you were worried about the utility hookups. You just don't plug a trailer into your sewer line. It's a whole new ballgame there. There's a hose that comes out of a fitting 4 inches in diameter and things like that. So it's not like it's an easy, give them some electric, they want to run their bathroom and all that, they can go to Flying J or they can go down to Forest and dump. So that's our only intention, is to let our fellow Elks members and their guests park there, and we probably don't have 10 of them a year. Just an off-the-wall number I pulled out of the sky. But it's not that common, but we've been allowing it last year, and quite frankly, I think we drew the attention to ourselves. One of our members, we wanted to put them 2 stanchions out, came up here to City Hall to get a building permit, to follow the rules, to put the stanchions in there, run the electric. And 2 weeks later, we had a visitor show up and our city police come by and said, you can park here, you cannot plug in. So that's what started the whole thing. And we're trying to do everything by the book. Like I say, we have absolutely no intention of opening an RV park. We're not in that business. We're in the community service business, supporting our youth and veterans, our two primary activities. So that's kind of what we want to do.
Thank you, Mr. Horner. Mr. Gabriel, so the question at hand?
Well, I think there's two questions. Is number one, I mean, do we come up with an intermediate definition of what it is that takes into account what they're doing, saying, these are what RVs are, this is what we do residentially, this is an RV stopover area, no sewer, no water, not more than 4 vehicles parked for 72 hours or something like that, and this is an RV park that's 4 or more, at any given time, that then maybe make it permitted in that area, so it's not a conditional use. I mean, I think one of the things, Scott, you said is, you have to think about what the worst case scenario is. It's not really the best, but I think that's number one, what we have to consider, and then number two is, they've applied for a text amendment, and, we probably should give them a vote on that text amendment, because even if you guys denied it, the Board of Aldermen may consider the text amendment, but it doesn't necessarily sound like, and I don't want to speak for the Elks, but do you guys necessarily want to go through the conditional use process, right?
Basically, I went off of Jack's recommendation.
We said permitted or conditional.
Yeah, permitted or
We just had to bring
conditional.
something to be considered.
Right, that's what he told me to word my application letter, and so that's what I did.
What about the concept of an intermediate definition?
Well, I want to tell Mr. Horner, first of all, I think everybody's very comfortable with how they'd like to use their property. I certainly am totally comfortable with the way that they want to use their property. What I'm totally uncomfortable with is changing C3 zoning in the entire city of Warrenton to accomplish that narrow use. So, now, I might be the only one that feels that way, and the commission can send this on with recommendation, or we could all believe that making this conditional in C3 is the wrong thing to do, and the Board of Aldermen could still do it anyway. But the whole point is to have the discussion, and my feeling from the beginning, having been here as long as I have, is that when we change our appendix, and especially when we put things that typically are conditional. Conditional means they may be good, they may be not so good, that when we put those conditional uses in the appendix, we open ourselves up to those unintended consequences. And I can't foresee what they are, but if we do it often enough, some of them will come back and bite us. And I want to protect the city so that we don't get boxed in. And I don't want to, in any way, keep the Elks from doing what they want to do. And my suggested solution would be, why not go Teresa's route and do the 10-day pink slip?
Well, I don't want to speak for enforcement purposes with regards to Jack or how you want to handle that.
Why is one different than the other?
Well, one thing was, most of the time, we don't have any idea we have guests showing up until they pull on the premises. Once in a while, we'll have our nationwide register, and they'll call and say, how do I get there, from here? And I can understand you gentlemen and ladies' dilemma, because I was a Board of Alderman member for 10 years, so I know you have to do that, and I've explained that to the rest of the board at the Elks Lodge, and they understand it as well, and the reason they pushed me to be the representative, because I have sat on that side of the bench, so I understand what you're going through.
So what was the issue? They can't run electric to the pole? I mean, that's my question.
Jack, can you...
Per code, when they had the camper sitting there plugged in, they were in violation.
Right.
And we made contact with the person in the motorhome, and he was very polite. Like Don had mentioned, he said he got their information out of their nationwide Elks book. He called ahead, he had reservations. He had no idea he was breaking
And we didn't
a
meet.
code.
Right.
I don't think it was, he was in his pajamas, he was ready to race down the road, and we said, absolutely not, you know. He said he has, I think he was the one who had family or something going on in Winsville, and he said, we're leaving tomorrow morning anyway. And we said, that's fine, we'll contact the Elks, because maybe they're not aware that this is against city code. And that's how it started. The gentleman spent the day there, he was extremely polite, and that's how we first made contact with the Elks. And when they made contact back, they asked, how do we resolve this?
So my question is though, since we've debated this for for 4 hours now, on 2 different nights, and had so many scenarios, what is the code that they broke? That's what I don't understand.
They had the motorhome plugged into utilities, which is in the definition.
Okay.
And what Chris proposed tonight is he had blacked out or drew a line through that section regarding being connected to utilities back in the ADM 67A on the definition.
But that was also with the idea of coming up with a new regulation for commercial, you know?
And residential.
And residential, yeah. The idea of like, okay, we're gonna regulate these and we're gonna change it, let's put a new provision here. And I think one of the things from an enforcement standpoint is, one of the biggest criticisms we get as a city is, you guys are not being uniform or you're picking on us.
Right.
And so we really make an effort to make our enforcement uniform citywide, so it's black and white. So that becomes the issue with the pink slips is intended, unintended, consequences, no consequences, whatnot, you know, and that's why, I mean, you know, and I don't know when you guys, is it the summer is really your high point, you know, where you guys really get travelers? Are you guys missing out on travelers right now?
We may be missing a snowbird or two, but because it's in the register and it hasn't been changed yet this year, most people will call.
Okay.
And
Because
it's on their way.
And I
They might
believe
be in
this-
St. Louis and say, okay, where's Warrenton, how do I get there? And
I think it was October was
yeah,
when we were called, and it's something for the record. If the city, specifically my office, receives complaints, we're obligated to go look.
Sure.
And if it's a violation, we're obligated to move forward on it.
I mean, my thought is, you know, do I come up with an intermediate definition for more of what, because they're really talking about an RV layover area.
Right.
Not an RV park. Not
Exactly.
people
Right.
staying there for an extended period of time, it's a layover area, less than 4 at any given time, using electricity only. That would be really easy to carve out a middle definition that we could make it permitted in C3, that I don't know is going to create the unintended consequences and give them an ability to do that.
So my question back is to the residential pink slipper over there, is when it's in front of her house for 10 days, is she allowed to plug it in? That's my question.
No, because she's in residential.
Per existing code, no.
For existing code, that's what I'm saying. But we were discussing a while ago for 72 hours to allow that.
Could Chris make the definition where it's a layover, whether it's residential or commercial?
That's what I'm saying.
And maybe limit it to,
72 hours or whatever.
or maybe not allow 4 in a residential area.
Right.
Well, who knows what Teresa wants to do over on her property.
I'm sure you don't get it coming.
In a residential area would be 1, because that's what you know, that would be common sense to me. I mean, or not. You know, that's kind of a good idea, I think.
Okay, so we can wrap this up. So we'll work on an intermediate definition. Are you okay, Mr. Horner, not having a vote on your text amendment so we can maybe refine this a little bit more? And because, understand, if the conditional use is denied, you'll need a supermajority at the board to get that approved. And even if it's approved at the board, which would be next meeting, you're still going to have to come back and get a conditional use permit. What we're talking about doing is creating we have residential RV layover area and then RV park, creating that middle one with the concept that we would, I guess, make it permitted. What do you guys think in R3?
C3.
C3, sorry, C3. Teresa's mucked this whole thing up.
Is there not some way that we can attach this strictly to the Elks instead of all of C3?
No, we can't, it would be spot, I mean, yeah.
That would be spot, we've never done that.
Yeah, and number 1, and number 2 would be, it would be the easiest thing to get a variance to say, you gave them this special use, we're not getting this special use. But I think that when you talk about a layover area, we can put a lot of parameters in that with what they're doing that kind of, you know, specifically defines what they're doing. For example, we could make it a 1.5 lot minimum with no other building on it, which is what you guys do right now. I don't know, are you guys planning on building anything on that lot and a half, acre and a half?
Hopefully in future years, we'll build a new facility and tear down our old one and make it.
But right now, you're not.
No.
So, I mean, we could like, you know, kind of create where it would be pretty difficult or pretty expensive to dedicate, you know, that kind of resource to it, because like you said, it's cost prohibitive to do it. Make it electricity only, no sewer, no water connection. You're not even letting them use the hose, right?
Right.
No.
Okay, no sewer, no water connection at all.
No.
Acre and a half.
No pavilion.
No pavilion.
No permanent cooking facilities or structures, no.
No, we're not planning on building any, so.
Right. I'm just saying so that we can make this a narrow enough definition to.
Yes.
Not
But
charging a
but point in
fee.
fact,
So-
any other
Oh, that's good.
C3
Yeah, that's
charging
good.
a
could
fee.
do that.
Because you don't charge.
Any
Okay.
other C3 property owner could do that. In other words, if they didn't have a lot that size, if they bought an adjoining lot and tore down whatever was on it, they could do that.
Right.
Do you
But if they can't charge a fee,
No, they just,
you can't charge a fee. Really eliminates the incentive to go to the expense, but, you know, I think you then only end up with situations like the Elks have where they're simply wanting to be good fellow Elks to
think they accept
travelers that pass
donations.
through.
Yeah, we got a donation jar. And shoot, you can go into our lodge and we have thing, you know, on Monday and Wednesday, well, basically every night we have popcorn. And there's a donation jar there. If you feel good about it, you can donate $1 towards a popcorn fund, you know, and we are a nonprofit organization, so. They know, we don't have a set rate like you go to a campground and it's $27 a night for this or that or anything like that.
No more than 4 RVs.
Now, how does that change from your prior concern with the subdividing down to, you know, 36 lots with no more than 4 on each?
Well, I think that we just don't even put that language in there, and we say it's, you can have up to 4 RVs on 1.5 acres. I mean, who's gonna put 4 RVs on 1.5 acres and not charge a fee, and it's gonna be a good investment? They would be, I think, literally doing that to be a nuisance. Put a time limitation, make it similar to the language we had in our proposed amendment, that it's a continuous running clock, no utilities except for electricity plugged in. Does that sound like that could work, Don?
Yeah, all we want to do is just put a plug-in out there.
Plugins out there, right, but kind of what we're saying, the parameters we're putting together, and it kind of reminds me of what we did with the fairgrounds, where we created a lot minimum, this, and this, so, you know, you can do those things. Does that sound like that could work, if we put those parameters? Is there anything else you guys want to do, or you see in the immediate or near future that you want to make sure we don't restrict?
The only thing we talked about, and this is all, you know, we have to raise the money to do it, was we were, Scott mentioned this, putting a small pavilion out there where we could barbecue, because we have barbecues every month, someplace for the workers to get under cover while we're doing that, or for the members, Easter Sunday, we'll have an Easter egg hunt out there.
But that
For
pavilion,
all the kids, you know. and
would that
someplace-
pavilion be used for the RV people?
No, not necessarily. That wouldn't be for the RV parkers, no.
Would it be on the same lot, though?
It'd be on the same big lot there, yeah.
But
I mean, that's the only place
You
we've
can
got
park an
really to
RV
go
on
to
a lot.
that's not
It's not
parking.
hooked up to electricity.
Right.
Could we limit it to a for-profit business or a not-for-profit business?
That's a tough question. I will tell you, my initial instinct is I would not be comfortable doing that. I would have to want to do a little bit more research on it, but, you know, I mean, it's not a sign where it's content regulation, but, I mean, it could be discriminatory in some senses constitutionally, so I would like to avoid, we've really gone away from the for-profit, not-for-profit. I mean, it would be a great idea, because once again, these are just things to narrow the field, you know, that allows them to do it, but I would probably prefer Scott to kind of leave that alone, but let me look at that and bring it back with suggestions for the meeting.
I'd like for the Elks to use the property for what they're talking about, but I don't want to see us screw everything up for 20 campers for maybe 2 nights a year. That's, it just doesn't seem worth it.
Yeah, and that would be my question. So my thought would be,
Unless we can word it some other way where we get around it.
can we take a stab at putting an intermediate together? And I know, Don, I hate to make you come back for another meeting, but you've been patient working with us to kind of put something together, because there's nothing that they can approve that would allow you to do it tonight, you know? It still would have to go in front of the board, and you still would have to come back with a conditional use permit to go through. But it's your choice if you want to vote on your text amendment tonight.
Well, I mean, and I think what I've heard is we can do the text amendment thing rather than the conditional use. I mean, we're still gonna have to come in here and get a building permit and all that.
Well, with the text amendment for permitted, you're saying, for for RV park in C3?
I don't know, Jack, how did we work
Yeah,
that?
you,
You gotta think back here, it's been a while since we wrote the
in
letter.
your letter, you were asking to change the zoning grid
Right.
to allow it as a conditional use, which would be a yes or no vote
Right.
tonight if they want to change the zoning grid, and then it would go before the board as a yes or no vote. I think what Chris is asking is, instead of changing the zoning grid, do we want to go back like we originally talked about the first time we tabled it, was actually changing a definition or creating a new definition that may allow, it may accomplish your goal
Right.
without changing the
Without
zoning
opening a whole
grid,
book
which
of
I believe the
other
changing the zoning grid has some concerns with the P and Z Commission,
Right,
or maybe creating a definition.
Well, we're going to have to
would
create
meet your
the definition
goals.
and change the zoning grid as well, because we're going to have to make it something on the grid as well, either conditional or permitted in C3.
I mean, either one, for us, you know,
You just want to meet your goal.
we just want to be able to use it for our visiting members to park there and for a couple nights usually at the most, and then go on.
And not be getting a letter from me.
Well, I mean, you know, we don't need the police coming by and walking up and
So you said
making
you're
sure
gonna do
nobody's
the
plugged in or any of that.
You're going to do a definition, plus we have to change the zoning grid?
Yeah, because we'll have to fit it into the grid somehow, you know, with C3. You know, we'll have to make it,
Right.
you know, but we could do that next meeting.
Next meeting, okay.
Basically, instead of approving campgrounds, you may call a recreational vehicle layover.
Layover.
That's
And then
what
if you're
I'm thinking.
making the definition of a layover,
We'll
then
call it
you're not
a-
allowing a campground, you're just allowing
Right.
a specific
So
item we're
campground
calling
is-
a layover.
Right, that this is very, and then anything more than what this is, so we may have to modify campground a little bit, but anything more than a layover area is a campground, and you know, kind of have that distinction, and then we'll have to change the grid and say permitted in C3 or conditional in C3. What do you guys think about permitted or conditional in C3?
Layover?
Layover area.
Teresa's driveway. The downside, the near-term downside to conditional is that then the Elks still have to come back and get their conditional use, whereas if it were permitted, it would be resolved.
But as long as-
You're trying to get it limited enough, that it's
Yeah.
not gonna be that big of a...
If we put the conditions in the definition to begin with, then
It'll be permitted.
I wouldn't have too much heartburn.
Okay. All right, so let's, if it's okay with you, Don, it probably sounds like that it would be better to kind of at least pose this mid-definition, and this is advertised for this, you know, adding it to the grid for next meeting, because we've kind of already put out the parameters, and then maybe have a vote on both, and then you can move forward after next meeting, if that's okay. And then kind of choose what you want to do. Does that sound reasonable?
Yeah, it does to me. I would appreciate if I can get a copy of what you're wanting to propose at the next meetings, because
Right.
I'm just one individual, you know, I'm a member of a
Sure.
300-plus person organization, and they've just kind of asked me to be their spokesman, and I want to make sure our governing board
Understands what's
is
going on.
okay with my thoughts, so that I don't go off on my merry little way.
I'm sure they'll all be perfectly accepting of your
Well, I'm sure they would.
representations here tonight.
Yeah, I'm sure they would, but I want them running past.
Yeah, that's fine.
And
We
that's
can-
respectful.
I mean, I think we can probably, Jack.
Once we
already-
have the P and Z packet ready, I can sure email it to you and set it up front, and you can pick it up.
Okay, that'd be great.
Yeah, I think we
Well,
already
I
have.
could share it with my board members, and then
If
we
you
can
can
motion to table that again.
either the Friday before or the Monday.
So moved.
With the permission of the
That'd be
So it'll give you a
applicant.
couple days minimum.
Sure.
So it was tabled, correct?
With Mr. Horner's permission, that's what we're going to do? Is that okay? Okay. Entertained a motion. Mr. Dickey has made a motion.
Whatever we gotta do. Move
Mr.
on.
Jurgenmeier seconded to table this and let Mr. Gerville and Mr. Hamp work on a bid definition as we discussed tonight. Any questions, comments? And Jack will provide Mr. Horner a copy of that when it becomes available. Roll call vote?
Mr. Barton?
Yes?
Mr. Schoenfeld?
Yes.
Mr. Jurgismeyer?
Yes.
Mr. Schwab?
Yes.
Mr. Dickey?
Yes.
Mr. Costello?
Yes.
Mr. Deitch?
Yes.
And Mr. Cullum?
Yes.
Motion passes 8-0 with one abstention. Next order of business will be the extreme terror haunts.
This is a proposed site plan approval request for Extreme Terror Haunts, SP 83, to be located at 1029 Armory Road. Property is Zone C3 Highway Commercial. An indoor entertainment facility is a permitted use within the C3 zoning district. In your packet, you have plans, drawings, and a letter of intent from the applicant. The Public Works Director has reviewed and approved this site plan request for items regarding the Public Works Department. The applicant is aware that a sign permit will be required, and the applicant requests that the landscaping requirements be waived or reduced due to the fact that the project area of the site will consist of the existing building, existing asphalt pavement, and a proposed gravel parking area. And I believe there's a representative here
Right.
tonight to speak on behalf.
Mr. Gravel.
Thank you, Don.
Any questions from the board?
So they will be using this space only for that 2-month period?
Yes, they'll be in there, obviously, to go and construct it. This thing will take, they were hoping to get in there in May, get it constructed. They'll have to do all the drive-throughs to it and everything else, and, the dry runs through it. And then they would go out to hire staff that have to do practices and, but actual business operations would be maybe the last week of September and the whole month of October. So literally 5 to 6 weeks max of actually business operations, with the intention to hopefully bring in anywhere between 10 to 12,000 people through Warrenton during that period of time to that facility, and also the restaurants and everything else in town.
And then would that stay set up for the next
They
year?
would go ahead, we have a 1-year lease with the landlord with a 1-year option, but during the off-season, you wouldn't know anything was in there whatsoever. It would be quiet in the building. It'd be more of a warehouse at that point until the next season again.
Be just like it is now.
Exactly, well, yeah. Yeah. So from that standpoint, it would be used strictly for that. The intentions and the goal of the gentleman would be that if it was to be as successful as we would hope to be, eventually a piece of ground would be purchased and a permanent structure would be built for not only this, but other amusement type things throughout the year.
Are the recommendations that the chief Owenby brought, are you familiar with those?
I just was handed to it tonight, and it was a little surprising because we had walked through with the chief, Jim Daly, and even the fire marshal back in the day when we tried to start this process 2 years ago. They said there's no issues with the building whatsoever because of the type of material we're going to be using. So, now we're going to have to figure some things out. I was talking to Mr. Gravel, but we'll have to figure some things out because this building is obviously not sprinklered. So we don't know, but at this point, we'll still continue with the process of trying to get site plan approval and figure out where we can go from there. I don't know if the landlords are going to spend the money on a sprinkler system on that building, but I have some other ideas we may be able to figure out.
And Mike contacted me, he said he saw my sign posted out there at the site and asked to share the information not only with the board but with the applicant,
Yeah.
to make sure that you were aware of this upfront
Right,
before
and
you invest more
Mike said
time
that he wasn't aware of this the
and effort
first
into
time
it.
we came through this process. We had actually went through, just kind of, we went ahead of time and said, hey, walked you through the building, and everybody's like, yeah, not a problem. And Jim Daly said, hey, as long as the fire department's on board, we're on board. And at that time, nobody was aware of this. Since then, it's become aware of it. It could have just been a new adaptation of the code or what have you.
You still want to go through the process for the site plan then?
Well, yeah, I mean, I don't know at this point, why not argue the point of it? I mean, I don't think my guy's gonna get his money back anyway from the whole site plan review, so at this point, if I leave now, he's gonna be a little disappointed, at least get his money's worth out of the site plan review.
Oh, and you have a year to, if the Board of Aldermen approve your site plan request, you have a year to complete it.
Sure, and
So you have plenty of time to try to work out.
we'll work some of that,
items.
and obviously with this particular situation at this current moment, the sprinkler system is more of just a problem that we're gonna have to figure out before we could obviously go to the next stage of opening up for business. So we may be back with a different site that I have in mind.
And here again, there were, oh, go ahead.
You're not planning on changing anything on the outside of the building, right?
No, at this point, the building will be what it is. He may come in eventually. At this point, he's not planning on doing it. If he was to do something, he would come in and ask for a special permit to do maybe, just like what people do to their houses, maybe some temporary decoration to the building, but nothing that would be permanent. You're not going to all of a sudden see a big black building or black and orange building or anything like that. The owners that own this building would not allow that to happen.
Okay. I don't really see anything wrong with the site plan myself.
As we all know, it's an old car lot. It's got plenty of parking. We're not adding any structures to it whatsoever. The front portion that was the area for the salesmen would actually just be more of a spot for the staff and everybody to come in and get ready for participating and acting in the event itself.
Anybody else have any questions?
I move we accept the site plan as presented with the proviso that the fire protection district concerns be addressed.
Second.
We have a motion by Mr. Deeks, second by Mr. Dickey, to approve the site plan as submitted by Extreme Terror Hunts with the additions that the concerns of the fire department be met. Any other questions or comments? Roll call vote.
Mr. Schoenfeld?
Yes.
Mr. Jurgesmeyer?
Yes.
Mr. Schwab?
Yes.
Mr. Dickey?
Yes.
Mr. Costello?
Yes.
Mr. Deitch?
Yes.
Mr. Cullum?
Yes.
Mrs. Scott?
Yes.
And Mr. Barton?
Yes, motion passes 9-0 with one absent. And thank you, Mr. Gagliano, for coming in. Appreciate you. Appreciate your
Brady
patience.
shot me a text. He said, I remember spending 2 hours arguing the RV stuff when I was on.
Yeah. Tell her we miss her. Tell her hello. And the last order of business on the agenda would be discussion of special events permit.
Mr. Dickey requested having time to address the commission.
Good evening, Planning and Zoning Board members. My name is Ron Dickey, and I'm a member of the Planning and Zoning Board. I'd like to speak to you tonight about special events. If you have any questions or comments, please hold them till the end of the presentation, and we can take them up then. I would like to talk about special events applications. I would like to reference the mud bog application that we had at our last meeting. The P&Z director did not get enough information for the applicant for a recommendation to the Planning and Zoning Board. The application was forwarded to the Planning and Zoning Board without a recommendation from the Planning and Zoning director. The Planning and Zoning Board did not have enough information, so the applicant was given instructions to what information to give the Planning and Zoning director before the next town board meeting. So the application was sent to the town board without a recommendation from the Planning and Zoning Board. The Planning and Zoning Director did not receive the information from the applicant prior to the town board meeting. The applicant presented the new information directly to the town board at their meeting. The board asked many questions of the applicant. They asked questions of the Planning and Zoning Director. I was in the audience and I was asked by Alderperson Casserly why I voted no at the planning and zoning meeting, and I told her that I did not get enough information and the drawings were not legible, and I thought the new information should come back to and be reviewed by the planning and zoning board, even if it meant having a special meeting if there was a time constraint. After much discussion, the board decided to table the matter with directions for the planning and zoning director to look over the new information and make a recommendation to the board at their next meeting on April 2nd. After passing through 3 board meetings and the planning and zoning director spending many hours on this, it was passed without any discussion and without the applicant being present. I would like to read to you some passages from our special event permit. This is our special event permit. Required documents, and I'm only going to read 3. Plans showing the intended uses and activities. Plans showing the intended uses and hours of operation of existing and proposed grounds, structures, parking areas, and outdoor lighting facilities. Plans showing necessary restrooms, facilities, crowd control, security plans, traffic control and traffic ingress and egress plans, lighting and noise control permit. I want to read you the definition of the word plan. A system for achieving objective, a method of doing something that is worked out in advance. Intention, something that somebody intends or has arranged to do. Layout, a drawing or diagram on a horizontal plane of the layout of the arrangement. There were plenty of mistakes made throughout this process, and some ill feelings evolved, and all of these things happened with good intentions in trying not to delay the applicant from the event which they had planned. When the town board gave the planning and zoning board the responsibility to review all special event applications and send a recommendation to the town board, my understanding of the process was that we would follow their direction, and over time, when we found that we were having repeat events and we had asked all the pertinent questions and tweaked all of the paperwork, that we could make arrangements to move those events from a special event to, for lack of a better word, a standard event where the same paperwork and drawings could go from the applicant to the planning and zoning director to the town board for approval. However, I have no problem looking at all special events as we do today. In my opinion, the main problem here is that the applicant does not have any standards by which they can give us the information that we need to make an informed decision. I do not feel that an informed decision can be made from a 1,000-foot aerial view of the fairgrounds. But that is all we have to work with for now. In my opinion, we need detailed scale drawings of the fairgrounds and all the buildings, gate openings, roads, parking area, fences, barriers, and any other permanent structures, and number all of these items on a legend on the drawing given their description. These drawings should be given or sold to the applicant by the Fair Board when they petition the Fair Board to hold a special event at their facility. Once a standard drawing has been made, a copy from that drawing could be altered to show the configurations for a mud ball, tractor pull, demolition derby, and so forth. The applicant could make copies of the drawings, and after the hearings with the Planning and Zoning Board, make additions or corrections for the next year's event, and after so long, it will become routine and a painless process for all parties. In my opinion, the drawings should be made by the Fair Board because they are hosting these events and are setting up the different events for the applicants. The Fair Board should know the dimensions of the mud ball and the configuration of the safety barriers that are needed to host the event. I do not think that the applicants who come before the Planning and Zoning Board can answer the questions that we need answers before we can move forward. Let me give you an example, and I will reference the mud bog again. Bear in mind that I do not know what a mud bog is, and I have never seen one. One of the things that I would want to know is where the mud bog is located in relation to the spectators. How long it is, how wide it is, how deep it is, and what will be in the mud bog besides mud. Will there be water standing on top of the mud? And if so, how deep will the water be? And what will be running through the mud bog? All of these questions need to be answered along with many others because of safety issues. The only people who can answer these questions are the people who dig and prepare the mud bog, and they are not present at the meeting. This is where a detailed scale drawing is needed so we can answer these questions by reading the drawing and not relying on the applicant for such detailed questions. The only questions the applicant should have to answer are ones they are physically in control of, such as parking cars, cleanup, hours of operation, security, will alcoholic beverages be sold, crowd control, and so forth. After our last meeting, I contacted Lewis and Bates to see if there was a detailed drawing of the fairgrounds, and they informed me that there were none because the buildings were erected over time and there were no up-to-date drawings. I asked him if they had a ballpark figure of what it would cost to make a detailed scale drawing of the fairgrounds and existing buildings, and they said it would probably be around $1,000 to $1,500. In my opinion, this type of drawing would streamline the process of special events and stop the confusion and ill feelings that are being created by not having standards to go by. 100% of the special events applications are being held at the fairgrounds facilities. I am not advocating that we stop special events until we get a standard drawing of the fairground, but rather that we cooperate with each other and see that they are handled in a professional and successful manner. In the end, the applicant, the fair board, the planning and zoning director, the planning and zoning board, the town board, and the citizens of the community are after the same things here, and that is to hold a successful event where everyone has a great time and everyone goes home happy, and most of all, without injury. I have found that there are some unique opportunities that arise during tough situations, if you only look for them. I do not know who we have to see, where we have to go, or what we have to do in order to make this happen, but I would like to see all the planning and zoning board members give this some very serious thoughts about what they would like to see on the drawings and sub-drawings that would be submitted to us, and I believe it will make life much easier for everyone in the future, and the process can be executed in a timely and harmonious manner with the applicant. I am not here to lay blame with anyone in this process. I am here seeking resolutions to these problems so we can become better equipped to execute our responsibilities. I appreciate your time and attention, and I am much honored to be a member of this planning and zoning board. If you have any questions for me at this time, I'd be happy to answer them.
Thank you, Mr. Dickey. Very well put.
I think a standardized drawing is an excellent idea.
I agree. It would be very helpful.
Again, I don't know who we go see about all this. And I'm advocating the fair board should do it because they're the hosting people that do this.
Well, and I think it's a great point, because when we talked about this conceptually with the Fair Board, we said to them, do you guys have a drawing, an engineered drawing with the buildings on it? And they said they did.
Yes.
They were like, yeah, we have that, no problem. And we said, give it to the applicant, that they then can draw the stuff on and where they're putting, so there's a standard drawing that they had. That was our expectations. Now, you know, I don't know what kind of record keeping they have or what's going on out there or whatnot. They've been great to work with. I think one of the issues we have is you know, I don't know how we could spend public funds for a survey of, you know, it's a corporation or an individual's property. You know, is there a public interest in there? You could maybe argue a public interest because it is where the special event permits are occurring. But I don't know that that could be a stretch there, but I wouldn't want to.
Well, why wouldn't they want to do this? And they could just pass on the cost to the people that are applying for their special events.
And that's maybe something.
Over a period of time, you know, they charge $50, that's 30 events.
I mean, I guess one of the questions is, you know, do you want Jack to communicate something to them about, look, we really need to get this on a drawing, you know, an engineered drawing for your special event?
That has been communicated to them, that they need to come up with a better drawing, and I think originally they thought they had something, and now it's the cost of getting one drawn is what's holding them back. But I don't know where the fine line is, can I refuse to accept an application? Because then you're opening up a whole nother can of worms.
Well, that was kind of the, really, I think where a lot of the issue lies, because Mr. Hanf can be criticized on the one hand if he says, you know, this does not look like it's providing the detail that is going to be needed for consideration, and says, you know, I can't present this for the meeting. Well, then he's made the decision on his own without bringing it to us. Although I think we all agree that what we had to review for the mud bog was, it was nowhere near complete enough to be able to understand and satisfy ourselves that those safety issues were addressed. And we said all that, and actually our discussion, I made the comment that, you know, we don't have enough information, yet we're talking about passing this on to the board and hoping that the information comes in the meantime. We're really kind of passing off our responsibility to make a decision on it and a recommendation on it, and just leaving it for the board alone to do. So I think the point that really ultimately we should say yes or no is a good one, that we, and we've done a number of situations over the years that I've been here that, well, we'll pass it on, not just special events, but we'll pass something on to the board recommending approval subject to the provision of A, B, or C. And that's intended, I think, to be, I guess, cooperative for whoever the applicant is, but at the end of the day, it kind of excuses us from making a decision. And it's probably a good point. But Mr. Hanf, I think, should have the authority to say, this document doesn't satisfy requirement 1, or this doesn't satisfy requirement 2, or whatever, and until I have these things in this format, this can't go before the Planning and Zoning Commission. And the Board of Aldermen, I think, would have to give Mr. Hanf the authority to say that, but that to me is the right thing to do.
Well, I think one of the things you guys can decide is, because I think the ordinance just says a drawing. It doesn't say, what does it say, Jack?
Provide plans showing the intended uses and activities, hours of operations.
Because that was the intention when we wrote it, was they had an engineer drawing, they could draw their stuff in there. Wouldn't necessarily be to scale, but the buildings would be to scale, the land would be to scale and whatnot. I mean, I guess my question would be, if they come in with another one that's just a drawing, hand scribed, or there is no drawing, are you guys going to accept that? Because I think you guys under the ordinance have to say, this is inadequate, we want more. Or we can go back and look at a revision to it to say, this has got to be the base drawing has to be a engineered drawing.
There should be a 8.5 by 11 drawing of the mud bog, given dimensions of the mud bog.
Oh, there's no question, but that's what...
And the Fair Board is the only one that knows this.
Right.
That applicant does not know, and we're asking the applicant, and they don't have a clue.
And Ron...
But the applicant is responsible for the event.
Right.
So the applicant is
Right.
responsible to provide the information.
And I understand what you're saying, Ron, because lady that came in and presented was like, she drew it to scale, she'd never drawn anything to scale, she used graph paper and whatnot. But
Exactly.
when we discussed the permit, that whole concept was, we suggested to them, you guys have an engineer drawing, you hand them the piece of paper, they draw it on there, with the idea that it would kind of be this hybrid. So, I mean, the concept was built on the idea that the Fair Board would be responsible for the engineer drawing to provide to the applicants to submit, kind of like, like a color page, like you just draw it in there and you put it on there and you have it. So, like I said, my question is, when they come up with more special event permits, do you want us to communicate to them that, look, P&Z wants to see this on an engineered drawing, so you guys need to get this done? I mean, that's my question. I mean, I think that would be the quickest way to say to them, this is what we need from you, or do you guys want to see what they come up with?
And I don't think the applicant can do that, really. I think the Fair Board has to do this.
Oh, and I think they would, I think they would have to,
Well, if you're requiring the applicant to do it, you're requiring, and then they're not sharing, you're requiring each applicant to spend between $1,000 and $1,500. And
that's not
and it's
what it
something
was.
that should only be done once, and then
Exactly.
there should be no more cost incurred.
Be in a database.
Yeah, so my question is, how long does it take to go from, no, we don't have an engineered drawing, to, yes, we do have an engineered drawing?
I have no idea.
How long would it take for
Lewis and Beatty
to get out there, draw it up, and come
The
up with
surveyor
it?
could go out there and have a day or two of field work and produce a drawing in 3 days, 4 days.
If you just
Or you
numbered
could
each,
probably get off of Google and AutoCAD, you could probably draw a pretty close one if someone put some time and effort into it. And I just want to state for the record, I believe my responsibility is to accept their application and do a plan review, which I do, and I give back a plan review response letter. And I specifically ask for additional information stating that I believe the P&Z Commission would request this information. And on this particular one, I asked for that repeatedly. I don't think I have the right to say, I refuse to present this to
You don't have
you
the right.
guys.
Legally, he
If
can't
they
refuse
submit
the
the application, I can put in writing that I believe you need to provide more information, and I put in writing that I cannot recommend approval, but I feel I have to present it to you guys.
Right.
Is that correct, Rick?
Yeah, it's a ministerial task. It's not he doesn't have discretion in accepting it and putting it in front of you guys. But I think that for the next one, if you guys say, look, we're not going to approve it without an engineered drawing, we can say to them, look, planning and zoning said they're not likely to approve this without an engineered drawing. You guys got to get that done for your next special use permit.
And we just did the one for the dog circus. That was 1,000-foot aerial off of Google Earth.
They all
guys
are.
accepted that. So should that have been an engineered drawing too? That's, I mean, if...
But once they have that, that'll be used every
Yeah,
time.
once it's there and existing, but I mean, should I have rejected that application?
You can't reject the application, that's not the
Right.
question. The question is, do you guys, and it's a new ordinance.
Well, I think
We
there's-
changed it again without a public hearing this
I think
time,
there's a difference in the one today was just inside this building. That's the only thing that was,
Okay, but if Mr. Dickey's requesting it for all special event applications, I agree we need to get something clear, but I also wanted to verify, my feelings is, I'm responsible to forward to you whatever application I get.
Right. We understand that.
Well, they do, if the Fair Board is going to continue to do it, use those special events, and they know we're not going to approve it without it, it'd be in their best interest to go ahead and get it and then share the cost with each special event entity that comes in and asks for it. If they have to charge $50 for it, that's not a big expense. But $1,500 would be a pretty good expense. for
And
them.
I believe the lady to put on the mud bug would have gladly paid $50
I'm sure
to
she
have
would have.
a plan to start off of.
Because it would have helped her.
I don't think we
Immensely.
should continue to pass these without having.
Because those applicants, like you said, are,
Is that something we can write a letter or send something to the
Well,
Fair
I
Board
think what we can
requesting
say
that, or
is,
how do
what
we
we can
handle
do
this,
is,
Chris?
if that's the consensus of the Planning and Zoning Commission, we can send a letter and call Paul, because I think Paul's, been very reasonable and good to work with, and say, hey, Paul, Planning and Zoning discussed this last night. You need to get, we talked we brought up to him that we originally talked about an engineered drawing. This issue came up with the mud bog. You know, they want you to present an engineered drawing as your base drawing. They want you to get that, so the applicants are doing it as we had previously discussed in the meeting. And invite them to a meeting to come and discuss it further, you know.
Do we need to pass a resolution?
No, I don't know that you guys necessarily need to vote, because, you know, there's nothing in front of you per se, and it's not an ordinance change. I think, you know, what probably would make most sense is for us to communicate, if you guys are in consensus, your intent of it, and that's what you guys want to see, and then, you know, see what kind of feedback we get back, and see if he wants to come to a meeting and discuss it further.
Sounds good?
Does that sound acceptable to you?
I'd love to meet with them and talk about it, really.
Does good?
It'll make this process a lot better, and hopefully we won't have any of the problems we had with this last one.
Yeah. I mean, no matter what issues there have been with the Fair Board, they've always been at any meeting and shown up for any meeting we've invited them or had with them. So, you know, I think we can express that, and they may just say, well, let's just get it done so we don't have to deal with this issue going forward.
I don't know what problems you had, but I still think you did okay.
Oh, yeah.
Thank you, sir.
Oh, it's up, yeah.
I do too.
All right, at this time, we'll close that meeting and offer Mr. Hampton time to give us any input.
For our next meeting, we will have a sign variance request to be presented to the Board of Adjustment, and we will have the step-up program site plan and conditional use applications.
And then update on the Title Max building, the work that's going on.
They're doing interior work right now.
I'll see you in a minute.
Setting a beam, they're wanting to revise, I got a call today, they're wanting to revise some items inside from the original plan, so he was emailing down some information to get plan reviewed. But
Everybody just wants to know what's going in there, you know, in
Huh?
town. Everybody just wants to know what's going on in there in town, so.
he's turned in a sign permit application, and that's approved, but I think he's waiting to get some other things done before he puts up his new sign.
It's kind of funny, though.
Put Title Max in the window.
Yeah. Anybody else have anything for the good of the group? Hearing none, we'll entertain a motion to adjourn.
So moved.
Mrs. Scott,
Second.
second by Mr. Deach, all in favor, say aye.
Aye.